Hi, this is Josh Blackman, and welcome to the round of eight. Today we have two teams from Lake Oswego High School in Oregon. We have Aria Hawk and Nidhi Nair representing petitioners, and Dak Steinbach and Zach Turner representing the respondents. Council, begin whenever you're ready.
Mr. Chief Justice, and may it please the court, my name is Aria Hoke, and along with my co-counsel, Nidhi Nair, we represent the petitioners, Ashley Moody and the state of Florida, in today's case. This court should find that the provisions of Florida's SB 7072 should be upheld, with our four main reasons being that the covered platforms are common carriers, social media companies lack editorial judgment, the Florida law includes narrowly tailored hosting requirements, and also contains disclosure provisions which will enhance user speech. This bill does not violate the First Amendment protections guaranteed to the social media companies.
Firstly, the covered social media companies are common carriers. Black's Law Dictionary defines common carriers as companies that offer services to the public over wire and satellite systems. And social media companies fall under this definition because they are major conduits of information within today's digital society.
State ex rel Webster v. Nebraska Telephone Co. established that although a telephone company imposed reasonable rules and regulations upon their customers, they were still obligated to fulfill the common carrier obligation of being indiscriminate in their dealings. Following the same logic as a common carrier, social media platforms are therefore also obligated to be indiscriminate in their dealings pertaining to the dissemination of content.
The 11th Circuit's decision held that the covered platforms are not common carriers because they make individualized content and viewpoint-based decisions about which content to disseminate, which was therefore considered protected speech and triggered First Amendment scrutiny. While the court based their ruling off of Turner Broadcasting v. FCC, we firmly disagree with their interpretation of the case. In reality, the 11th Circuit ruling asserts that the must-carry rules are content neutral and thus are not subject to strict scrutiny, and the challenge justification does not justify the application of First Amendment scrutiny.
It is also important to consider that while SB 7072 requires platforms to host speech they normally wouldn't, the legislation doesn't entirely eliminate all censorship and regulation of content, like obscenity, for example. The social media companies must apply whatever censorship, deplatforming, and shadow banning standards they adopt in a consistent manner among their users, which demonstrates how the law is narrowly tailored to enhance user
All right,
speech.
Counselor, let me jump in if I can. Can you tell me what kind of companies are subject to the Florida law?
The companies in the regulations, it says that any social media company that has gains over $100 million in revenue in a year or has 100 million people visit their site in a month.
Okay, so would this law apply to Gmail, for example?
This law would likely not apply to Gmail because it only caters to big social media behemoth companies that are in the net choice training.
But is the definition social media? I think you gave me a different definition a moment ago. Is it only social media, or is it just large companies? Or what's the statute actually apply to?
I believe the statute just applies to the size of the company itself in order to regulate.
That's right.
Yeah.
So let me give you an example, right? Let's say that tomorrow Google decides we're going to start deleting all emails from, Republicans. Would would the statute be would the statute prohibit that? Would the statute create a liability for that?
No, because that's not content neutral. And they would say that the censorship needs to be applied in a consistent manner, and censoring just Republican speech would not be consistent among all users and the speech that they disseminate on Gmail.
In
Okay.
addition to that, sorry.
Let me ask you a question then. Did the plaintiffs in this case bring a facial or an as-applied challenge?
The plaintiffs, oh, Your Honor, the plaintiffs in this case brought a facial challenge.
Okay. So can you tell me, please, under this court's precedents, what do you have to show to succeed in a facial challenge?
Your Honor, I'm not quite sure right now.
Okay. So, as a general matter, in a facial challenge, the plaintiffs must show that there's no legitimate sweep where the statute could be invalid, right? What happens if we find that the statute, might be unconstitutional with regard to Facebook, but can be validly applied to, like, Instagram, I'm sorry, a Gmail or a site like that? How should the court handle that sort of situation?
In the case where SB 7072 is found to be applicable to different types of platforms such as Gmail, I believe that it should still be upheld because in terms of disseminating content, platforms like Gmail still are common carriers of information and major conduits of information for people in today's society to share information with each other and be able to receive connections with other people. So similar to social media, though we as petitioners are arguing that this bill does not violate the First Amendment, it should still have some broader application to other platforms that also disseminate content and information to each other.
Okay. But my question is a little bit different.
Mhm.
What happens if we hold that the facial challenge fails, but an as-applied challenge might work? What happens to this case then? I'll ask your friend on the other side the same question in a few minutes.
Okay. Well, Your Honor, we can see that in the Supreme Court, when they recognized overbreadth doctrine in two decisions, Thornhill v. Alabama and Cantwell v. Connecticut, the court held that breach of peace statutes or peaceful and truthful discussions of matter of public interest and violent actions alike, that you can't wholesale ban that labor. And in both of these opinions that the court ruled, they said that these laws could not be broadly construed to suppress free communication of views, religious or other, under the guise of conserving desirable conditions. However, in both cases, the court refrained from invalidating the statute itself, instead calling for a limiting construction of its applications.
So how does severability play into your argument? Can you tell me that, please?
Yes, I was saying, Your Honor, I assert that if the court were to find that it was an as-applied challenge, that they, instead of invalidating the statute itself, could instead call for a limiting construction of its applications and narrowly tailor it in the way that the court deems it as applicable.
But what exactly would the court sever? In other words, which parts of the law might survive, which parts of the law would not survive?
The 11th Circuit decision upheld the content regulations that were included within SB 7072, but struck down the individualized discretion that needs to be provided on a case-by-case explanation for each instance of shadow banning, censorship, and deplatforming. So I believe that although the content regulations should regardless be upheld because it promotes the marketplace of ideas, if this case were to lead to severability, the case-by-case disclosure would probably be the most at risk.
If I may, I think what I'm more interested in is if we decide that Gmail, for example, is subject to the law, but that Facebook is not subject to the law, what role does severability play there? Could we sever the law on a platform by platform basis?
If the court deems that they want to invalidate the statute that defines what is applicable via the $100 million revenue or the 100 million users on the site, then in that case, they could sever that and only apply it to Gmail and not Facebook. However, that definition as the large monopoly is kind of essential to the heart of the case, which is that these large companies have such a huge place in today in society and control so much speech and content that exists on their platforms. So if the court were to rule that, then that's probably what they would slash from the actual bill itself.
All right, Counselor, can you discuss a couple of cases, Tornillo, PGE, and Hurley?
Tornillo dealt with Miami Herald v. Tornillo dealt with newspapers being required by state law to feature information about political candidates, which allowed them to reply. And that was found to violate the First Amendment because it dealt with violating editorial discretion. However, the same cannot be said for social media companies because newspapers have a message that is intertwined with their content that they publish. However, social media companies simply disseminate content. In addition, the respondents also cite Hurley, which deals with a parade and excluding people because they don't align with the speaker's message. However, obviously under the First Amendment, things like newspapers, press, and parades are protected. The same cannot be said for social media companies because they have no message in the first place.
All right. Counsel, let me ask you one more question. Why does this sort of editorial judgment have to happen at the front end? Why can't the enforcement of the community standards itself be an exercise in editorial judgment?
The enforcement of community standards and terms and regulations is not an enforcement of editorial judgment. It's just a standard of baseline rules and regulations. But in the end, social media companies are still required, because they are common carriers, to be indiscriminate in their dealings. So just because users will agree to terms and services that simply filter out harsh things like obscenity doesn't mean that social media companies control the entirety of their speech that they disseminate on the platforms.
Your Honor, I see we're running a bit low on time. May we conclude?
Okay, go ahead.
Thank you. While it may be tempting to assume that social media is the same as a newspaper, the covered platforms lack First Amendment protection and do not have editorial judgment. We urge the court to side with these arguments and uphold Paxton.
All right, thank you.
Thank you. Can we just move on?
Okay. Respondents, you guys can switcheroo and we can do it again.
Okay.
Okay, whenever ready, Counselor.
Mr. Chief Justice, may it please the court. I'm Zach Journey.
I'm Dak Steinbeck.
And together we represent the respondents of the Moody v. NetChoice case. To briefly go over the facts once more, politicians and lawmakers in Florida perceived an unfair bias in how large social media platforms are regulating their sites. In doing so, they created Senate Bill 7072, which enforced that social media websites should be treated as common carriers. This court case was first found in Florida, which ruled in favor of NetChoice. And then later in the 11th Circuit, again, the 11th Circuit ruled in favor of NetChoice, reinforcing the lower court's ruling.
Today, we hold that SBF 7072 imposes restrictions on private companies' right to exercise editorial judgment over their own websites. It discriminates on the basis of content, speaker, and viewpoint, in addition to compelling speech. Florida does this with the intention of upholding free speech, but loses sight at the main principle of the First Amendment, which is that it only applies to state action. As private companies, websites use their editorial discretion to create and enforce policies targeting speech violating their code of conduct, community standards, and generally speech they don't agree with, such as hate, abuse, violence, and child endangerment. We find that private companies are subject to the same First Amendment protections as found in Manhattan v. Halick. And by only platforming certain speech, these companies, quote, invoke its right as a private speaker by speaking on one subject or remaining silent on another, as found in Harlan. These restrictions don't hold up under strict scrutiny triggered by First Amendment violations.
SB 7072 regulates the content and display of particular websites and prevents websites from regulating their content. Tornillo, PGE, and Hurley all hold that you cannot force the dissemination of third-party speech while rejecting the considerations of misattribution, market power, and space constraints. Reno and 303 specifically hold that these First Amendment protections also uniquely apply to social media websites. As well, the individualized explanations for each censorship or regulation of content is also uniquely burdensome and could dissolution of the internet we have today.
We contest that Florida's law does not pass the Zoller standard, as the individualized explanation requirements are unduly burdensome and therefore chill the platform's protected free speech. As an important
Counsel, if I may, what's the procedural posture of this case?
The procedural process of this case.
You mentioned that you won in district court and then you won again in the 11th Circuit Court of Appeals. What did those courts rule on? What did they give you?
Your Honor, these courts ruled that NetChoice is not a common carrier; it is a private company. And
has the case gone to trial yet?
You mean
this case is not going to trial, Your Honor. This case is a facial challenge because we see that Senate Bill 7072 could have such a large impact on the free speech rights of these private companies. And,
okay. And what I'm really trying to get to is the lower courts, they granted a preliminary injunction. Isn't that correct?
Yes, Your Honor.
Okay. So if we were to decide in favor of you, what should we do with that? Should we send it back to the lower courts to decide the trial? Should we invalidate the law as a whole? What solution are you looking for?
Your Honor, I think that the best course of action for the court to do is that either to send this down to a lower court and figure out the facts of the case, whether like what the Senate bill actually means when they say that the regulations should be done in a consistent manner. The Senate bill doesn't have an explanation for that or what that means. Or the court can defer to Congress as they do with other social media regulations, like Section 230 of the Communications Decency Act. This shouldn't be.
Let me sort of jump in on my friend's question, the other side, my friend's question. If you brought a facial challenge, right? Let's say that we agree with you that the law is invalid as applied to social media companies. But let's say we think the law is valid as applied to Facebook. I'm sorry, as applied to Gmail. Doesn't your facial challenge fail?
The facial challenge, Your Honor, Net Choice argues for a facial challenge because we believe every part of this case is invalid. I believe that it does not, it should not apply to Gmail and it should not apply to
Well, again,
Twitter at all.
let me give you the example that we talked about a few minutes ago. What happens if Gmail just starts deleting messages from Republicans or Democrats? You delete all Rachel Maddow's emails because you don't like what she has to say. I mean, wouldn't the Florida statute, sort of provide a cause of action for that? You could sue for that?
No, Your Honor. We believe that as Gmail is a private company and it is providing a service with conditions for every user, that if they decided, we might not be comfortable that Gmail would ban users from using their platform, but Gmail is just only one of many email internet service providers, and they fully have the right to.
Well, but isn't
ban
that sort of the
content.
problem with a facial challenge? You have to show that there's a plainly illegitimate, or you have to show that the sweep of the law is illegitimate. And I think if your friends on the other side can show a plainly legitimate sweep of the law, and they say that as applied to Gmail, the law would be valid, then I think should you lose?
Yes, Your Honor. I think the difficulty here is that the law does not really have a good definition of what a social media platform is, and I think it is arguable that there's a difference between Gmail and Twitter, for example. For example, Gmail could be compared to a dump site where it does just give one information from point A to point B. There is no censorship in that regard. So it's not clear what a social media website is, and it could be argued that there is a difference between Twitter and Gmail.
And I think,
but let's say we don't agree with you, right? Let's say we think that by the plain terms of the statute, Gmail will be covered, PayPal will be covered, Venmo will be covered, Zelle would be covered, Uber, requesting a ride, we won't give rides to Democrats or Republicans.
I apologize, Your Honor, you cut out there.
could you repeat the question?
I'm sure, and I think you're cutting out too a little bit.
Yeah.
I mean, what if we decide that you're wrong and that Venmo's covered, Gmail's covered, Uber's covered, Cash App is covered, all these various things which look like common carriers are covered? Wouldn't that mean your facial challenge fails?
No, Your Honor. When we look at how this law can be applied to unintended companies such as Uber, Amazon, and Etsy, we don't think that these companies would be able to discriminate based on like who uses it, and it would instead be focusing on the comment sections of these websites, such as Etsy. Under a certain, like products that are listed, there's comment sections like reviews, and that would be what companies would be able to have an editorial judgment over, which they do today. And
if I could interrupt just for a moment, please, isn't there at least some doubt about whether the statute applies to Gmail and so on? Shouldn't we send this back to the lower court to take another look at it, even if we're not sure? Because you need a
Yes.
lot to win a facial challenge. So should we send it back to the lower court?
Yes.
Well, if we send it back to the lower court, don't we have to vacate the injunction? Don't you lose? I mean, do you really want that? It's not a trick question.
If we
I mean, if we send back to the lower court, that means we get rid of the lower court ruling, which you like, which you prevailed upon. So what do we do?
We want to send it back to a lower court because we don't believe that this case is there's we see this in Biden v. Knight. This case has a lot of it's very complicated. There's a lot of flaws to it. We want to send it back to a lower court so this can be relooked at and reevaluated until we have all the facts and a good case. We don't want it to be ruled in the Supreme Court. We want the facts. We want a good strong case.
But we still believe that the Supreme Court should uphold the injunction on this law before it can be applied to social media, because there's still a way for the court
But
and
how do we,
for all
again,
parties
how do we,
involved to.
but the injunction the court issued
Mm.
was based on overbreadth, applied to everyone everywhere at all times, right? But if we think that the facial challenge is flawed, wouldn't we have to vacate the facial challenge injunction and let the trial court give another go on the as applied challenge?
Well, yes, Your Honor, but I don't believe it even passes an as applied challenge. I think in the 11th Circuit there are certain parts of the law that even the 11th Circuit found, aren't particularly burdensome, but there are still parts of the law that are.
But isn't this your problem? I mean, look, you chose to bring an facial challenge. You could have brought an as applied challenge. This was your choice. You didn't have to. And you decide to bring a facial challenge. If it doesn't work, that's your problem, not ours. Why is that Florida's problem? If the statute can be applied validly in some regards, why wasn't that end this case and we can let the lower court figure this out?
Your Honor, so we heard everything up to the question. Could you repeat the question?
You chose to bring a facial challenge. You chose not to bring an as applied challenge. That's not Florida's problem. Why should we leave an injunction in place based on a facial challenge if that doesn't work?
Your Honor, we believe that we believe that we brought this facial challenge to the court because we believe that if this law were to go into effect, that the damage to social media websites and the internet as a whole
Why didn't you
would be.
bring an as applied challenge? Why didn't you say we bring it as applied to Facebook, Twitter, and so on? Why did you seek to invalidate it in all regards?
We don't believe that in any regard there's any social media website that is not a private company. That is why we believe that all private companies
Again,
are, you know.
again, the Gmail example I think is not good for you, and we talked about this before. I think also the Uber example is not good for you. You know, in many regards, Uber looks like a taxi, right? Right? It's a common carrier.
Mhm.
You know, Gmail looks like maybe a telegraph company. It's just transmitting messages. Venmo looks like a bank, right? You have to give financial services to everyone. Um, I get it. You say that we can't regulate Facebook as a common carrier. I get that. But these other things look a lot like common carriers. Why can't, what First Amendment right does Facebook have, does Venmo have to reject customers? I mean, what First Amendment right do they have?
uh, Companies like Venmo, companies like Uber, Amazon, and Etsy don't have the First Amendment protection to deny someone service of their main products, such as Uber denying someone the right to get rideshare from another user. What they do have First Amendment protection, though, is the editorial discretion of what they
Counsel,
allow in their comments, what they allow.
I'm sorry, but I don't think that that helps you because what you're describing is conduct, and conduct is exactly what the Florida law is trying to regulate. So saying that Uber is sort of not covered under the First Amendment sort of strengthens the argument I think my colleague is trying to make.
Yeah, yes, Your Honor. I want to emphasize what we're trying to say. I want to bring up a case, First National Bank v. Bellotti, which emphasizes that Twitter, YouTube, Facebook, these social media websites specifically have First Amendment protections, and that's what we were trying to say. Is that the law has a very vague definition, but there are cases that do define that Twitter, YouTube, Facebook, TikTok, these are private companies that have First Amendment protections, and that's what we wanted to emphasize.
Sure, and I think the question is, assuming we agree the law is invalid as applied to those companies, what do we do about other companies like Gmail or Uber? Because the law still applies to them. And so if we're invalidating an entire law based on a facial
Um,
challenge, then that's a problem for you.
Well, Your Honor, I'm Your Honor, I think that the way that the Florida law is so unspecific, it doesn't specify what companies that this applies to. It only says that internet service providers that like offer a service online. Because the Florida law is so, vague, that it should be struck down as a facial challenge because the court plainly just doesn't know, and that the Florida
So we
law
send
should
it back-
reconsider how the
So
wording.
we send it back to the lower courts, but we remove the preliminary injunction.
Yes, that would be fine.
So that, I think that means your side loses though,
Why is that?
because your side is the one seeking the preliminary injunction.
If we send it back to the lower courts, they could rule again in our favor.
They could, but the law would be in place, and so you will have lost at the Supreme Court.
Okay.
Your Honor, we're running a little on time. May we conclude?
Yes, should be a wrap up.
You know, that if we believe this is a facial challenge, which we do, and we want to argue in case of a facial challenge, we want to emphasize that this law is not narrowly tailored and therefore triggers First Amendment protections as found in Zotter. And this is not just conduct, this is discernible speech. As we find in Sorrell, it is disseminating content, even though it's third-party content, it can be found to have a left-leaning bias to it, which then is speech. And therefore, since this is not narrowly tailored, since it is not conduct and it is speech, the court should rule in our favor. Additionally, since it is pointed out in Net Choice opinion that it is not narrowly tailored, that it's actually tailored to cause as much problem and conflict as possible for the social media websites, as defined in First National Bank, for example.
Okay, thank you, Counselor. We have 5 minutes rebuttal time. Switcheroo. All right, Counsel, begin whenever you're ready.
Thank you, Your Honor. The respondents argued that if users want to participate in a free conduit of information, they could just go to a forum. However, that is exactly what we here as petitioners are arguing for today, that these very covered platforms themselves already are common carriers and forums of information. Social media companies exist as platforms for people to share ideas, speech, and opinions, which is the whole point of having an account on one of these sites in the first place. As a common carrier, NetChoice has an obligation to be indiscriminate in their dealings, and therefore SB 7072 is rationally related to the legitimate government interest of protecting user speech. Associated Press v. Labor Board and Associated Press v. United States asserts that the First Amendment rests on the assumption that the widest possible dissemination of diverse and antagonistic sources is essential to the welfare of the public.
Well,
Command that the
I
government-
get that. I get that, and I understand that you're really extolling the First Amendment rights of people to speak. But do you deny that Facebook and Twitter have a First Amendment right to curate and display their information?
No, Your Honor. Facebook and Twitter and social media companies that are protected within SB 7072 are not newspapers. They don't have the ability to act as a speaker.
They're not newspapers, you know, in the classical sense, but don't they function a similar role as newspapers? They share information, you learn about things, you can find things, you can, you know, interact with people. I mean, isn't that more or less what a newspaper does?
No, Your Honor. Newspapers publish their own content. They create it on their own, and they have a message that they're clearly trying to convey with the information that they publish. Social media companies merely distribute information, which was affirmed in Justice Thomas's opinion of Biden v. First Knight.
Okay, you proceed.
Thank you.
As I was going to say, a command that the government itself shall not impede the free flow of ideas as stated in the First Amendment does not afford non-governmental corporations a refuge if they impose restraints upon that constitutionally guaranteed freedom through claims of editorial judgment or expression. The First Amendment affords not the slightest support for the contention that a corporation restraining trade in news and views has any constitutional immunity.
The respondents additionally referenced cases like Harlan and Tornillo. However, excluding speech because it does not align with the speaker's message is only protected under the First Amendment for editorial discretion. Since the freedom of press and assembly are explicitly stated in the editorial judgment, whereas social speech does not interfere with the platform's own message because the platforms have no message.
Oh, yeah.
Shopping malls because of a niche distinction between the speaker who claimed his rights were violated in Pruneyard.
Okay.
Establishes that businesses.
Counselor, hold on. You're breaking up. I'm having trouble hearing. I'm sorry.
Your Honor, would you like me to repeat?
Yeah, can you just repeat what you just said the last 30 seconds or so?
Yes. However, the respondents denied shopping malls because of a niche distinction between the speaker who claimed his rights were violated in front yard. However, the rather establishing that businesses do not have a First Amendment right not to be forced by the state to use their
v. ACLU as an explanation for why SB First
sorry.
Amendment. However,
Daniel, the same, Alex, you can't hear them.
Yeah, about 5 seconds we hear, 5 seconds we don't.
Yeah, I'm sorry. You have a minute left. You can just wrap up. I'm sorry, the tech's not working. You can conclude, Counselor. Go ahead.
Respondents cite Reno v. ACLU as an explanation for why SB 7072 violates the First Amendment. SB 7072 is not like the Communications Decency Act because it's content neutral. Communications Decency Act aimed to remove certain content from platform standards, which violated the First Amendment. But SB 7072 simply requires manner among users. If they want to establish community standards on their platforms, can you still not hear us?
It cuts out every 5 seconds. I think we're good. We'll say probably the best we're gonna have today. All right. Thank you, Counselor. All right. The case is submitted. All right. Let me turn this off. Well, thank you very much. And don't worry about the tech problem. These things happen. If you do another round, I don't know if there's bad wireless in your area or there's a different bad connection, or maybe are you using a laptop or a Chromebook?
But it was just break when we started this oral argument and then class started, so I'm assuming more people.
I see. More people joined on after it started. Yeah, we didn't have this problem when I went to school. There was no wireless when I exited. That's fine. All right. So if the other two can please come back on screen so we can talk to you as well.
Let them scoot their rolling chairs over here.
I see them rolling. Okay. That's an old song.
Oh my God.
You got that one. Good.
Yeah.
All right. Congratulations. That was extremely well done. I think both teams are, I'll use the word mature. I don't mean that to say that, you know, you're older than you seem, but you are. You have a lot of poise, far more than a bunch of high school students usually do. And here's what I mean by that. I asked you a lot of questions that I'm pretty sure you didn't know the answer to. And you didn't, you know, panic. You didn't freak out. You didn't, you know, say something bad. You handle it responsibly. So at one point, one of you said, I don't know. You can say that, right? You're allowed to say, I don't know. It's a lot better as a lawyer to say, I don't know, than to make up an answer and then mess your client up and actually screw up your case, right? The worst thing you can do is say, yes, Your Honor, to a question that you don't understand, because then you just conceded something that you don't even know what you conceded. Is it, wait a minute, you said yes? That's the opposite of what you did before, right? So never answer a question that you don't fully understand. I think both of you did well. Also, I think you were pushed out of your comfort zone a little bit. I know a lot of your briefing in the competition has been about the First Amendment, but if you notice, almost all the questions that I asked were about things that you didn't write about facial challenges, right? About as applied challenges, about you know, what do we do on remand to the injunction, right? We asked about severability, and these are the sort of issues that these are the sorts of issues that are at issue in this real case. In fact, if you listen to the oral argument, and for Aria and Nidhi, you should absolutely listen to it. I wish you had done it before today, but you know that's where we are. You'll see that almost all the questions are about Gmail and Uber and Venmo and PayPal, right? There was almost no question about the First Amendment. It barely came up. So I think what the court will actually do with this case is to actually sort of dump it on some sort of ground, saying, well, you know, maybe the statute is valid in this regard, but not valid in this regard. We'll have to think about it later, but we send it back to the lower court. And then the $1 million question: what happened to the to the, what do you call it, to the injunction that's in place. Now, at one point, I asked the respondents, should we remand it? And you said, yeah. And I'm like, what? No, when you are at the Supreme Court and you had a victory below, you should fight to keep that lower court decision in place at all costs. Do not give in an inch on that, right? Because the second it gets back to lower court, you might lose. You got a victory, right? You got a W. You got to keep your W, right? The flip side is for the what do you call it, for the response of the petitioners. By the same token, when I ask, can we leave the injunction in place if we vacate the lower court decision, you have to find a way to say no to that answer. I think that has to be your answer, that you want to get rid of the injunction and let this go forward, even if they have to figure out the Venmo and the PayPal stuff as well. Say, well, Your Honor, this is the plaintiff's fault, right? They brought in a facial challenge. That's their problem. And I tried to sort of tease that out. But the questions I'm getting, the feedback I'm giving you now is super high level, right? This is not about, this is not the advice I give in the first round, like, well, congratulations, you guys are good, you're polished, whatever. I'm giving you now the sort of the very deep legal arguments that will, I think, actually win this case for, whichever team advances to the next round. What else do I want to say? Another thing is you have to stop reading. I know you have to prepare notes, and you asked if you could read your I think you asked me if you could use your materials from last time. I don't know if you asked if you could read them, but you should have the stuff committed to memory. It's not easy. If you want to have notes sort of glance in every few minutes, you can, but I think you need to have a clean memory to actually give your opening statement. When you get to the Supreme Court, there's actually a rule that says you cannot read. Now, that's not always the rule. Some courts let you read, but at least here we try to simulate the Supreme Court, which is maybe successful or not. But you have to be able to have your statement committed to memory. I can't remember, maybe Alex or Daniel remember, at one point, I think Alex asked either Zach or Dak a question, and then you responded by asking Alex a question. You can't do that. I can't remember if it was Zach or Dak. I can't remember who did it, but you can't ask the judge a question. And Alex answered the question. He's a nice guy. But I would just say, as counselor, we asked the questions here, not you. Right? I've used that line before in the court. I get the instinct because you're kind of having a conversation, and it's a conversation, but it's a one-way conversation, right? Where you're answering the questions. If you don't get a question, you can say, Your Honor, I'm not sure I understand the question. Don't ask it back to him. Or you say, Your Honor, I think the court is asking about XYZ, and sort of just trail off. And the court would say, no, that's not what I'm asking. I'm asking about ABC. So there are ways of asking a judge a question without asking a judge a question. I think that's something that you sort of get with practice. But really, both of you are very polished. I would just use the word again, mature. I think you really come across as skilled advocates. You're still like what, 17 years old, 16, 17 years old, 18?
17.
17, 18, right? So the fact that you don't know all the nuances of facial and overbreath challenges is fine. I mean, I taught this to my students in class this week, and they're all like law students, right? They don't even know this stuff before they come in. So it's fine if you don't know things, but what you both teams have is basically a very good innate skill to respectfully argue with clear tone, clear diction. There wasn't any slurred words. There's no pauses. There's no ums or buts. No, I thought both teams did very well. I'm very pleased with how you've done. I think you've improved also from the prior rounds, which I judged. So thank you so much. Alex and Daniel, anything that you want to add?
Yeah, I'll just go ahead and say we were very tough on you, and that's because we expect a lot of you. This is getting close to the final round. So one thing I really appreciate is Aria, when we were asking about facial challenges, you reached for the overbreath doctrine, and that's actually sort of the relevant doctrine that you should have reached for, and that was something that not a lot of other advocates really picked up on. You didn't know the exact test, which is that we were looking for, the plainly legitimate sleep, but I mean that's okay. I think that would have been remedied if you had listened to the oral arguments, because that was sort of big talking point there. So I mean, if going forward, looking at the next round, if y'all make it, highly recommend listening to the oral arguments, because that was really what they talked about. And I don't think the next round will be in front of us. I think it'll be in front of new people asking new questions, probably the same types of questions that the Supreme Court justices asked. So keep that in mind. For the respondents, I was very tough on y'all, so I kind of want to kind of apologize a little bit for that, but it's a sort of a difficult situation that respondents are in, because while it's true that you could have the preliminary injunction removed and then still win for your side, and that would be a win for net choice as a whole, probably down in the lower courts, you really don't want to give that up, because like Professor Blackman said, you don't know what's going to happen, especially once the Supreme Court gives sort of an inkling of how they feel about this case. It could sort of change the entire thing. So just keep that in mind. You want to hold your ground and fight for that preliminary injunction. Preliminary injunctions, it's not super fair because it's a civil procedure, and you've been focused on the First Amendment kind of thing, but you could argue that the factors that we look at for preliminary injunctions are still relevant, right? Because you could still argue, listen, for net choice, we're still going to win on the merits. Net choices, the penalties are hundred thousands of dollars, and so that cause that sort of like damages it's the harm suffered, whether or not it's irreparable is another question, but that's really getting into the weeds of the procedure questions. But you really want to hold on to the wins that you do have, like Professor Blackman was saying. I mean, I think both of you are really solid teams, and so that's why I felt like I could push you as hard as I did. Yeah.
Yeah, I really don't have anything else to add. All my points have already been addressed by the previous justices. But I do want to echo at the beginning, just make sure you have those 2 minutes committed to memory. It really adds to your overall persuasiveness. And because this should be more, conversational than it is just like standing up and giving a lecture. And if he's sitting there just reading off a piece of paper, it can give that off. But other than that, great job. Clearly, both of y'all deserve to be bronze. Good job, guys.
Excellent. What questions you have for us?
I have one. I applied standard. So when you guys told me that it was a facial and part of it.
I'm so sorry. You're breaking up. I couldn't hear your answer. I'm really sorry. Try it again, please.
I'll just keep it.
Maybe type the question. I feel terrible. I can't hear you. You break up every time.
I can type it. Then maybe something will get through. Oh my gosh. I think no, I'm just a very bad at typing. You know what? Circuit ruled as an as applied.
Okay, let me read the question 1 second. No, that's not correct. And I hope we can hear us. The plaintiffs only brought a facial challenge. And when you bring a facial challenge, that's the only thing the court can decide upon. And the 11th Circuit held that the facial challenge succeeds, that the statute is basically unconstitutional in virtually all of its regards. What the Supreme Court's saying is there might be some circumstances where it's not constitutional. Okay. All right. That answer your question?
Professor Blackman.
Yeah.
I think I know what he's asking because of a good question. So you're talking about the fact that the 11th Circuit severed part of the law, right?
Yes.
Okay.
Oh. Okay. Severability. Okay, sorry. Thank you, Alex. This is why I have very smart students. Severability is different than bringing a facial or as applied challenge, right? With the severability analysis, the court says that certain parts of the statute can survive, right? But The problem here is that the broad definition of what the law applies to. This is my question to the petitioners first. Does the statute apply to Gmail? The core provision of applying this to basically large tech companies would mean it applies to Gmail as well. Those parts were not severed. In other words, the very same provision that applies to Facebook would apply to Gmail. And the court says in 11th Circuit, this is unconstitutional in all regards. And then now the Supreme Court saying, well, it may be unconstitutional for Facebook. No, I'm sorry, it may be unconstitutional for Facebook, but it's valid for Gmail. So it's not about severing out parts of the statute, but the same provision which applies to Facebook and Gmail. Does that make sense?
Yeah, yes.
Thank you.
Very good question, though. I'm sorry I didn't quite get it in the first go. What other questions you have?
I understand what you're supposed to say now.
I think we're good on questions.
Good. Okay.
Awesome. I think we're
I
ready.
think we are frozen.
Okay. Thank you so much.
Okay,
All right. Well, that's all I have. We are adjourned here. Daniel and Alex, just stick around for a minute, and I will we'll be in touch probably maybe by Wednesday or Thursday with the scores. Okay.
Thank you.
thank you so much.
Thank you so
you.
much to everyone from Oregon. Thank you.